सभी साथियों को नमस्कार। उम्मीद करता हूँ आप अपने एग्ज़ाम की तैयारी बहुत ही डेडिकेशन से कर रहे होंगे। दोस्तों, आज का जो ऑडियो मैं बना रहा हूँ ये बहुत ही ख़ास ऑडियो है। बहुत सारे स्टूडेंट्स ने डिमांड की थी एक लेंथी वीडियो के लिए, और आज का जो ऑडियो है मैं उम्मीद करता हूँ कि आप इस ऑडियो को जो डिक्टेशन के रूप में है आप इसको ज़्यादा से ज़्यादा शेयर करेंगे उन सभी स्टूडेंट्स के साथ जो किसी भी एग्ज़ाम की तैयारी कर रहे हैं और वो लेंथी डिक्टेशन को लिखना चाहते हैं। तो आज की डिक्टेशन 30 मिनट की रहेगी और ये डिक्टेशन बहुत लेंथी है, इसलिए आपको एक चीज़ ध्यान रखनी है कि बाय चांस कोई एक आध वर्ड इधर उधर हो जाए तो आप उसको एडजस्ट कर लेना, क्योंकि डिक्टेशन को बीच में रोकने का कोई माध्यम नहीं है। 30 मिनट की लंबी डिक्टेशन को रिकॉर्ड करने में मेहनत खूब लगेगी, तो आप इसको ज़्यादा से ज़्यादा शेयर करिएगा और लिखने के बाद अपने जो एक्सपीरियंसेस हैं वो भी ज़रूर शेयर करिएगा। सो बी रेडी फॉर द डिक्टेशन। स्टार्ट। Heard Shri Rahul Shrivastava, Learned Counsel for the defendant appellant. None appeared for the plaintiff respondent despite service. After having lost from all the three courts below, the defendant to the suit has preferred this appeal. The plaintiff respondent instituted a suit for eviction of the defendant appellant from the suit premises, which is part of H768 JJ Colony, Shakarpur, Delhi, and for Mesne profits on the averment that he is the owner of the said property by virtue of an agreement to sell dated 10 April 2002, power of attorney, a memo of possession, and a receipt of payment of sale consideration, as well as a will of the defendant appellant bequeathing the said property in his favor. The possession of the suit premises was handed over to the plaintiff respondent pursuant to the agreement to sell. Subsequently, on the request of the defendant appellant, the plaintiff respondent allowed the defendant appellant to occupy the ground floor and one room on the first floor of it for a period of 3 months as a licensee. The defendant appellant failed to vacate the suit premises despite expiry of the license period and termination of license. Wide notice dated 18 February 2003. The defendant appellant contested the suit on the ground that the aforesaid documents have been manipulated on blank papers, but without disputing the execution of any of them, or that the possession memo was not executed, or that the sale consideration as per the agreement was not paid. The trial court, after framing 3 issues, the first being with regard to manipulation and fraudulently obtaining the alleged documents, the second regarding the right of the plaintiff respondent to get the defendant appellant evicted, and the third with regard to entitlement of Mesne profits, decided all the issues against the defendant appellant. A categorical finding of fact was recorded that there is no evidence to prove that any of the above documents were obtained by misrepresentation, manipulation, or by playing fraud upon the defendant appellant. The plaintiff respondent has proved his right over the property, and since the license of the defendant appellant stands determined, he is entitled to a decree of eviction and payment of Mesne profits though not at the rate claimed by the plaintiff respondent, for which there is evidence, but at the rate of rupees 1000 per month for the use and occupation of the premises in dispute. The leave was granted and the appeal was admitted probably on the question as to whether the above documents, namely the power of attorney, the will, the agreement to sell, coupled with possession memo and the receipt of payment of sale consideration, would confer any title upon the plaintiff respondent so as to entitle him to a decree of eviction and mesne profits. The aforesaid point was not raised by the defendant appellant through his pleadings in the trial court or the first appellate court, and therefore the High Court in second appeal held that he cannot be permitted to raise such an issue, and that the appeal as such does not involve any substantial question of law. The suit, as per the pleadings, is that of eviction and mesne profits on the averment that the plaintiff respondent is the owner of the property. He has claimed ownership on the strength of the aforesaid documents, especially the agreement to sell and the memo of possession, as well as the receipt of payment of sale consideration. No doubt, agreement to sell is not a document of title or a deed of transfer of property by sale, and as such may not confer absolute title upon the plaintiff respondent over the suit property in view of section 54 of the Transfer of Property Act 1882. Nonetheless, the agreement to sell, the payment of entire sale consideration as mentioned in the agreement itself and corroborated by the receipt of its payment, and the fact that the plaintiff respondent was put in possession of the suit property in accordance with law, as is also established by the possession memo on record, goes to prove that the plaintiff respondent is de facto having possessory rights over the suit property in part performance of the agreement to sell. This possessory right of the plaintiff respondent is not liable to be disturbed by the transferor, that is the defendant appellant. The entry of the defendant appellant over part of the suit property subsequently is simply as a licensee of the plaintiff respondent. He does not continue to occupy it in capacity of the owner. In the wake of the finding that the above mentioned documents have not been fraudulently obtained or have not been manipulated, treating the said documents to be duly executed and as genuine, one thing is clear, that the plaintiff respondent is in a settled possession of the suit property, at least in part performance of the agreement, which cannot be disturbed or disputed by the transferor, that is the defendant appellant. At the cost of repetition, the suit is for eviction of the defendant appellant from the suit premises and for recovery of mesne profits on the ground that after the defendant appellant has parted with the possession of the property in favor of the plaintiff respondent in part performance of the agreement, he has no right to disturb his possession. He is simply a licensee, and the license having been terminated, he has no right to remain in possession but to restore possession to the person having rightful possessory title over it. It goes without saying that the power of attorney executed by the defendant appellant is of no consequence, as on the strength of said power of attorney neither sale deed has been executed nor any action pursuant thereof has been taken by the power of attorney holder which may confer title upon the plaintiff respondent. Non-execution of any document by the general power of attorney holder consequent to it renders the said general power of attorney useless. Similarly, the will dated 10 April 2002 executed by the defendant appellant in favor of the plaintiff respondent is meaningless, as the will, if any, comes into effect only after the death of the executant and not before it. It has no force till the testator or the person making it dies. The said stage has not arrived in the present case, and therefore even the aforesaid will in no way confers any right upon the plaintiff respondent in connection with the general power of attorney, and the will so executed, the practice, if any, prevalent in any state, or the High Court recognizing these documents to be documents of title or documents conferring right in any immovable property, is in violation of the statutory law. Any such practice or tradition prevalent would not override the specific provisions of law which require execution of a document of title or transfer and its registration so as to confer right and title in an immovable property of over rupees 100 in value. The decisions of the Delhi High Court in the case of Veer Bala Gulati versus Municipal Corporation of Delhi and another following the earlier decision of the Delhi High Court itself in the case of Asha M. Jain versus Canara Bank and others, holding that the agreement to sell with payment of full consideration and possession along with irrevocable power of attorney and other ancillary documents is a transaction to sell, even though there may not be a sale deed, are of no help to the plaintiff respondent, inasmuch as the view taken by the Delhi High Court is not in consonance with the legal position which emanates from the plain reading of section 54 of the Transfer of Property Act 1882. In this regard, reference may be had to two other decisions of the Delhi High Court in Imtiaz Ali versus Naseem Ahmad and G. Ram versus Delhi Development Authority, which inter alia observe that an agreement to sell or the power of attorney are not documents of transfer, and as such the right, title and interest of an immovable property do not stand transferred by mere execution of the same unless any document as contemplated under section 54 of the Transfer of Property Act 1882 is executed and is got registered under section 17 of the Indian Registration Act 1908. The decision of the Supreme Court in Suraj Lamp and Industries Private Limited versus State of Haryana and another also deprecates the transfer of immovable property through sale agreement, general power of attorney, and will instead of registered conveyance deed. Legally, an agreement to sell may not be regarded as a transaction of sale or a document transferring the property rights in an immovable property, but the prospective purchaser, having performed his part of the contract and lawfully in possession, acquires possessory title which is liable to be protected in view of section 53A of the Transfer of Property Act 1882. The said possessory rights of the prospective purchaser cannot be invaded by the transferor or any person claiming under him. Notwithstanding the above, as the plaintiff respondent admittedly was settled with possessory title in part performance of the agreement to sell dated 10 April 2002, and that the defendant appellant has lost his possession over it and had acquired the right of possession under a license simpliciter, exhausted his right to continue in possession after the license has been determined. Thus, the defendant appellant parted with the possession of the suit property by putting the plaintiff respondent in possession of it under an agreement to sell. The plaintiff respondent in this way came to acquire possessory title over the same. The defendant appellant as such ceased to be in possession of it as an owner, rather occupied it as a licensee for a fixed period which stood determined by valid notice, leaving the defendant appellant with no subsisting right to remain in possession of the suit. Para. The order dated 28 October 2009 passed by the Punjab and Haryana High Court in RSA number 1449 of 2009 has been challenged in the present appeal. By the aforesaid order, the appeal filed by the appellants was dismissed and concurrent findings of facts recorded by the trial court as well as by the first appellate court were upheld. The dispute pertains to demand of additional price for the allotment of plot to the respondent number 3. The respondent was allotted plot number 1084 in sector 14, part Hisar, wide allotment letter dated 21 August 1986. Notice was issued to the respondent by the appellants on 15 January 1993, raising demand of additional price as well as to show cause as to why the plot should not be resumed on account of non-construction within a period of 2 years of allotment. The aforesaid notice was followed by subsequent notices, and the last being dated 28 January 2002. A civil suit was filed by the respondent on 1 October 2003 challenging the demand raised by the present appellants. The same was decreed. Aggrieved by the same, the present appellant filed appeal which was dismissed by the lower appellate court. The appellants did not succeed even before the High Court. The learned trial court accepted the plea raised by the respondent on the ground that in terms of the conditions contained in the letter of allotment, the demand of additional price could be raised only in case of enhancement in cost of land by the competent authority under Land Acquisition Act As in the case in hand, there is no enhancement in cost of land awarded by any court or authority. Therefore, no additional demand could be raised. The argument raised by learned counsel for the appellants is that the land in question was transferred by the Animal Husbandry Department, Haryana, to the appellants at the rate of rupees 1,21,000 per acre. However, later on the rate was revised to rupees 3 lakh per acre. On failure, the appellants were not to be given possession of the land. The allotments had been made by the appellants on 21 August 1986 at the rate of rupees 224.90. Initially, when the plot was allotted to the respondent, calculation of price was made taking the cost of the land at rupees 1,21,000 per acre. However, later on the cost was increased to rupees 3 lakh per acre. An additional price was demanded. The price of the plot was worked out at rupees 301.70 square yard, and the additional demand was raised from the respondent at the rate of rupees 76.80 per square yard. It was also stated in the notice that though the cost of development charges has been increased in the last 5 to 6 years, however, still the appellants will bear the same. As the cost of the land to the appellants increased, the same had to be borne by the allottees. The appellants being non-profitable organization, it was further stated in the notice that in case the respondent is not ready to accept the allotment of plot on payment of an additional price, he may get his deposit back along with interest at the rate of 10% per annum. On the other hand, learned counsel for the respondent pleaded that in the case in hand, one of the conditions in the letter of allotment was that the price of the plot was tentative. The additional price can be demanded only on account of increase in cost of land awarded by the competent authority under the Land Acquisition Act. It is admitted case of the appellant that the land on which the plot in question was carved out was not acquired, rather it was transferred by the Animal Husbandry Department of the state to the appellants. The price thereof was determined at the time of transfer. However, in case later on different price is determined, the allottees cannot be made to bear the increased cost. Heard learned counsel for the parties and perused the record and relevant documents. The fact that a plot was allotted to the respondent wide allotment letter dated 21 August 1986 at the cost of rupees 224 per square yard is not in dispute. It is also the admitted case of the appellant that the land on which the plot was carved out was initially owned by the Animal Husbandry Department of the state, which was transferred to the appellant. The initial price was fixed as rupees 1,12,000 per acre. The cost of plot was calculated including the cost of development, and allotments were made. It transpires from the record that later on the rate at which 275 acres of land of Animal Husbandry Department was transferred to the appellants was revised to rupees 3 lakh per acre. Whether burden of additional cost of the land could be put on the plot holders was the issue before the courts below. The relevant clause as contained in the letter of allotment regarding demand of additional price is extracted below. Para. The above price is tentative to the extent that any enhancement in the cost of land awarded by the competent authority under the Land Acquisition Act shall also be payable proportionately as determined by the authority. The additional price determined shall paid within 30 days of its demand. The aforesaid clause was interpreted by all the courts below to mean that the additional price can be demanded in case there is enhancement in cost of the land awarded by the competent authority under the Land Acquisition Act. It is the admitted case of the appellants that the land for allotment of the plot was never acquired. Hence, there could not be any enhancement in the cost of the land by any authority or court under the Land Acquisition Act. From these undisputed facts on record and the terms and conditions contained in the allotment letter, there is no illegality committed by the learned court below in setting aside the demand of the additional price of the plot allotted to the respondent. There is no merit in the present appeal. The same deserves to be dismissed, ordered accordingly. For filing the present frivolous appeal, in our opinion, the appellants deserve to be burdened with heavy cost. This court had deprecated the conduct of the litigants in flooding this court with frivolous litigations which are choking the dockets, as a result of which the matters which require consideration are delayed. This court must view with disfavor any attempt by a litigant to abuse the process. The sanctity of the judicial process will be seriously eroded if such attempts are not dealt with firmly. A litigant who takes liberties with the truth or with the procedures of the court should be left in no doubt about the consequences to follow. Others should not venture along the same path in the hope or on a misplaced expectation of judicial leniency. Exemplary costs are inevitable and even necessary in order to ensure that in litigation, as in the law which is practiced in our country, there is no premium on the truth. Courts across the legal system, this court not being an exception, are choked with litigation. Frivolous and groundless filings constitute a serious menace to the administration of justice. They consume time and clog the infrastructure. Productive resources which should be deployed in the handling of genuine causes are dissipated in attending to cases filed only to benefit from delay by prolonging dead issues and pursuing worthless causes. No litigant can have a vested interest in delay. Unfortunately, as the present case exemplifies, the process of dispensing justice is misused by the unscrupulous to the detriment of the legitimate. The present case is an illustration of how a simple issue has occupied the time of the courts and of how successive applications have been filed to prolong the inevitable. The person in whose favor the balance of justice lies has in the process been left in the lurch by repeated attempts to revive a state issue. This tendency can be curbed only if courts across the system adopt an institutional approach which penalizes such behavior. Liberal access to justice does not mean access to chaos and indiscipline. A strong message must be conveyed that courts of justice will not be allowed to be disrupted by litigative strategies designed to profit from the delays of the law. Unless remedial action is taken by all courts here and now, our society will breed a legal culture based on evasion instead of abidance. It is the duty of every court to firmly deal with such situations. The imposition of exemplary costs is a necessary instrument.